Fellow landlords of New York, many of you are jubilant and happy that you can finally get your tenant into eviction court, housing court, to get that coveted judgment and warrant of eviction without having to worry about that declaration of hardship hanging over your head, delaying the eviction longer and longer and longer. As we all know, the eviction moratorium in New York State is officially over. However, for those of you that are now going to be getting court dates to evict your tenants, you must do this prior to applying for your court date. Because if you do not, your case could easily be dismissed and you'll have to start over again. And that which you must do is this. This is the Landlord Advocates, where we help landlords become better landlords. I'm your host, Matthew Lyman. Welcome. Landlords, when you apply for a court date in New York, you have to give the court a copy of the rent reminder notice, commonly known as the 5-day notice, a copy of the 14-day notice, any certified mailings that you've done for those, or your process server or your attorney has done, affidavits of services, stating how those notices were served upon the tenants, and then obviously the court documents, the petition and notice of petition, telling the tenants that they have to come to court in order to tell the judge why they haven't paid the rent or why they haven't moved. Now, prior to doing this is very, very important. Even though the moratorium is over, any predicate notices served upon the tenants, that's the rent reminder, the 14-day, the 30, the 60, and the 90, would have been done prior to the end of the moratorium. That being said, every document that you provide to the court, the affidavit of service and the 14-day rent reminder, 30, 60, 90, should also have included with that, and on the affidavit of service, that the tenants were served the declaration of hardship, the 14-day or whatever it was, and the notice of legal service providers should be on the affidavit of service, and copies of those documents should also be attached to the rent reminder and the affidavits of service for everybody that was served. Just don't give the affidavit and a copy of the 14-day notice to the court. Many of you have had these notices served way prior to this past Saturday, January 15th, 2022. If you do not add those documents, you may very well see your case dismissed. Now you might be saying, Matt, why is that? It's over with, it's done. Yes and no. When those notices were served upon your tenant, the eviction moratorium under the COVID Emergency Eviction Foreclosure Prevention Act was still alive, still existed. So you would have had to give those notices to your tenants. Now, will some courts look at it and say, if you don't include it, it doesn't matter? They may. But why take the risk? When you submit your court papers for a court date, have a copy of the declaration of hardship, that dreaded document that we've all hated for months now. Have that attached. Have a copy of the notice of legal service providers attached as well. There's also another document that the state had provided. We call it at our office the State Unified Court System Seal. It's a document at the top is the state seal. It's on one-page form. That should also accompany every affidavit that you give to the court. So you have a Jane or a John Doe, include with that a copy of the 14-day or the 30, 60, 90, the state seal document, the declaration of hardship, and the notice of legal service providers. That should be attached to every affidavit. I cannot say it enough. I cannot tell you enough. You need to have this included. Yes, it may be over with. Any document that you serve as of Tuesday the 18th, Any document shown as of the 18th of January 2022 does not need any more of that bull. All you need is the 14-day, 30-day, 60-day, 90-day. That's it. You don't need all that other bull that we've had to include all this time. So that when you get 4 days after that, you won't need any of these other documents that are required now. Again, include a copy of the State Unified Court System seal document. Include the Declaration of Hardship. Include the Notice of Legal Service Providers. Now, some courts require, with that Declaration of Hardship, one that has not been completed, where your name and address and phone number and email is on it, and the same with the tenant. They require a blank one as well. Why? I have no clue. I have no clue why they want a blank one. The one that's filled out with your information and the tenant's information is the one that the court uses in order to say you can't do an eviction. You know that's dead now, but some of them require that. Yes, it's bull. Should we have to do it? No, but it's going to be required in many, many courts that you do so. So include all of those documents. I don't want to see, a landlord advocate does not want to see, your fellow landlord does not want to see your case dismissed because you failed to include 3 or 4 sheets of paper on an affidavit of service. Again, some courts may say, it doesn't matter, we don't care, it doesn't, not needed, don't worry about it. But don't take that foolish, stupid risk. Don't do it. Include those documents along with a copy of your notice of petition and petition, the original that is, and go to your local court and file for that court date ASAP. But don't do so without those other documents. Landlords, this is a day to be happy. Finally, the moratorium is over. ERAP is still biting us and choking us and getting after us. You know ERAP is not that good either, but at least part of this moratorium is over. Landlords, we ask that you subscribe to our channel, hit the like button, hit the notification bell, leave comments below, and of course, share this with every landlord. Something so simple could have their cases dismissed. Until then, landlords, take care.